Welcome once again to Lehto's Law. Here's Steve Lehto.
Kevin sent me a note. Says, Steve, check out the story from Reuters. Judge cuts Bayer $2.25 billion Roundup verdict to $400 million. And Dietrich Knuth wrote that. And, here's the question. Let's suppose that you've been injured and it's somebody else's fault. How do you monetize the injury? How do you put a dollar value on it? And it is very, very difficult. And so when you hear stories like this, when the jury awards $2.25 billion, where does that number come from? And is it right or wrong? How would you figure that out? And so there really is no correct answer on some of these things, because if I walked up to you right now and said, tomorrow your leg is going to get broken, how much is that going to be worth to you? I'd rather it not happen at all. Okay? So a Pennsylvania judge Tuesday slashed a $2.25 billion U.S. verdict against Bayer down to only $400 million for a Pennsylvania man who said he developed cancer from exposure to the company's Roundup weed killer. The jury in Philadelphia found that the man's non-Hodgkin's lymphoma was the result of using Roundup for yard work at his house for several years, and it ordered Bayer to pay $250 million in compensatory damages and $2 billion in punitive damages. And that's another question a lot of people ask is, okay, I understand compensatory damages to make you whole. Okay, this hurt you this much, you get made whole. Now we're going to punish the company and make them pay this even bigger amount of money. And so some people do question whether that's the role of a civil lawsuit or not. Again, some states, you hear about these very, very large punitive damage awards. Some states don't really have these, at least this much. So the judge granted some of Bayer's post-trial motions challenging that verdict, reducing the compensatory damages to just $50 million and the punitive damages down to $350 million. Now, Bayer says it's going to continue appealing this, challenging the trial court's decision to allow the jury to hear what it called misleading and inflammatory testimony. And you have to understand that to win a case like this, you've got to prove to a jury that the harm occurred, the harm was their fault, and you got to make this person whole. And so how do you determine whether the use of this product caused this cancer? So both sides are going to bring in experts. And the plaintiff side is going to bring in an expert who's going to go, I've examined the case, I've studied the file, I've looked at the medical records, and I am reasonably certain, to a degree of medical certainty, that this product caused that cancer. And I didn't see any of the trial, but I guarantee you that Bayer brought in at least one expert who said, no, we've done studies, we know all about the science, and there's no connection between that man's cancer and our product. None whatsoever. And so it often does come down to a battle between experts, and then, of course, it's up to a jury to decide. So a spokesperson for the company said, while the court's decision reduces the unconstitutionally excessive damage award, we still disagree with the ruling on the liability verdict, as the trial was marred by significant and reversible errors. Bayer also called for U.S. legislative reform to protect companies whose products comply with federal labeling requirements. Now, the attorneys for the plaintiff said they were pleased that the judge upheld the jury's finding that Roundup causes cancer. So they're saying, 'cause remember, there's several elements here. One, you got to prove that this caused that. Then you got to figure out the dollar value. So they're saying, look, the liability is still there. So they're happy about that. The plaintiff's attorneys also said they intend to appeal, seeking a reinstatement of the $2.25 billion jury verdict. And keep that in mind, that if you go to trial and you lose and you ask a judge to fix something and the judge fixes it and you're not happy with that and you say, I'm going to appeal this. On appeal, the other side can go, hey, the judge screwed up by reducing the amount. We want that money back. And that's not as likely to happen, but I've seen it happen. It does happen from time to time. So remember that when you file the appeal, you're giving the other person a second shot also at possibly making things go their way. The reduction of the amount of the jury's verdict is a clear departure from established Pennsylvania law that we plan to address on appeal, says the attorneys for the plaintiff. Bayer has said that decades of studies have shown that Roundup and its active ingredient are safe for human use. Roundup is among the most widely used weed killers in the U.S., though the company phased out its sales for home use last year. Bayer has prevailed in 14 of the last 20 trials on this subject, but they've also racked up some losses in late 2023 and early this year, resulting in more than $4 billion in verdicts. Some of those verdicts, like this one, were later reduced, but the cases ended a 9-trial winning streak for Bayer, and it also caused some investors and the company itself to wonder if it's going to get any better or if it's going to continue being bad. About 165,000 claims have been made in the U.S. against the company for personal injuries allegedly caused by this product, which Bayer acquired as part of its $63 billion purchase of an agrochemical company called Monsanto back in 2018. Most plaintiffs, like the one here, allege that the product caused non-Hodgkin's lymphoma. In 2020, Bayer settled most of the then pending Roundup cases for up to $9.6 billion, but failed to get a settlement covering future cases. More than 50,000 claims remain pending. And yes, that is a daunting thing to look at if you are working for a company and you're in the legal department, because they got to hire outside counsel for most of these. And you're hiring all these law firms to defend all these cases. And one of the things you have to do as a corporation is talk about how the business is running and what your costs are and your profits are and all that stuff. And you also have to talk about liability of the corporation. And so you got to say, well, we resolved 100,000 cases, but we got 50,000 cases left. And oh, by the way, one case just wound up with a jury awarding over $2 billion. And it doesn't take a real pessimist to go, wait a second. One case, $2 billion, and you got 50,000 cases pending. Yes. But you can't just multiply them all out because, we did win 9 in a row there. Well, and so, again, I'm not even sure what to think of this. I've read so much stuff about science in the courtrooms and the claims about this, the lymphoma and the Roundup. That's one of them. There have been other ones out there, though, where somebody says, this corporation put this product on the market, it causes these injuries, and the injuries are grievous injuries. And don't get me wrong, if I got cancer and I thought it was caused by a product and experts told me, yes, there's a connection there, then I'd be in court too, So, but this Roundup thing's been going around for a little while. And I think I've done videos about a couple cases in the past. I'm not sure it was Roundup, though, but I remember seeing multi-billion-dollar verdicts in cases. And then, of course, quite often on appeal, they get brought down. And so for those of you who are curious, you can always, as a post-trial motion, that is a motion you bring after the trial's over, you can ask the court to do a variety of things, including just throw the verdict out. Judgment notwithstanding the verdict. Just throw the verdict out and say that the plaintiff gets nothing. That's always a possibility. That's one thing you always ask for. That's kind of like asking for a home run, okay? But you can also ask for the judgment to be reduced, and it can be basis for doing that based on anything such as there might be laws in a particular state as to how different things can be added up. The compensatory damages are one thing, the punitive damages are another. Quite often, the courts will say that your punitive damages must be tied to some kind of other number, whether it's tied to the compensatory damages as a multiplier, like, oh, you got damages of X, well, the punitive damages can be 3X. That's one possibility. Another possibility is you might be able to base the punitive damages on, say, for instance, how much money the company makes, because, and here's the thing, without those, if somebody's got a product on the market and they know it, and again, I'm making stuff up here. I'm not talking about this case. I'm talking about cases in general. If you had a product on the market and you were a company and the product is making you money, hand over fist, as they say, and somebody comes and goes, by the way, our product's hurting people. Really? How badly? Well, let's say 1 out of every 1,000 people who use it gets injured. Okay, let's assume they all sue us. How much will each of them get? And somebody could sit down and do the math and go, okay, it still makes sense for us to keep the product on the market. Who cares? If all we got to do is compensate these people for the harm done to them, we make enough profit to do that. Let's just keep doing it. full speed ahead. And so an argument can be made that without the punitive damages, why would a company stop doing something like that? So that's the other side of the coin. I'm not saying I agree with either side. I'm just pointing out the law as it is, because that's what I do as an attorney. So this is an interesting case, but the real thing you got to look at is it started out as a $2.25 billion verdict, okay? And the judge knocked it down, and the defendant says, well, we're going to take it up on appeal to see if we can get it lowered even further. The plaintiffs say, well, while we're there, we're going to ask to have it raised back up again and see what happens. So what you really like to see in a case like this is where the parties can get together and settle it. Now, will they? I don't know. But occasionally you'll see a case like this where it'll quietly go away and somebody goes, whatever happened to that one case? And they'll go and look, and it turns out that there's something entered with the court that indicates the parties have dismissed it with prejudice due to a settlement. And the settlement is confidential, and nobody else knows about it. Now, some echoes of that will pop up in the corporate statements that get issued to shareholders down the road, but whether it's exactly clear as to who got what, it's not always the case, but the case could still settle. But if not, it could wind its way through the courts for quite some time. And that's the final thing I want to mention to you is how long this litigation can take. And let's assume that you're a plaintiff, you got injured grievously, and you won a trial. The trial was an ordeal. You went through weeks of testimony and sitting there and testifying yourself. Then, after the jury comes back in your favor, the other side asks the court to set it aside. The court modifies it a bit. Now they say they're going to appeal it. And in some states, it can be years, literally years, to go from the trial court to the Court of Appeals. And of course, if they don't like the appellate version, they can take that to state Supreme Court, and they might have other arguments to make along the way. So we'll see what happens. It might take a while, but as of right now, the judge cut the Bayer verdict from $2.25 billion down to $400 million. And Dietrich now wrote that for Reuters, and Kevin sent it. Thanks a lot. Questions or comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. Age is something that does not matter unless you are a cheese.